Information Disorder here at the School of Environmental Design and Rural Development, University of Guelph, Canada. Today's webinar promises to be an exciting one as we explore the legal aspects of AI and robots in climate-smart agricultural practices. Before I proceed, I would like to alert you all that this session is being recorded to ensure that this content is available for future learning and reference purposes. We will now commence by delivering the land acknowledgement. The School of Environmental Design and Rural Development, CEDRED, is committed to honoring and strengthening our relationships through respect and responsibility with the indigenous nations across Turtle Islands. We acknowledge that the lands on which we reside are the traditional territory of the neutral Anishinaabe, Haudenosaunee, and the Métis people. Today, this place is home to many First Nations, Métis, and Inuit peoples. Acknowledging them is an act of reconciliation, reminding us of our important connection to each other and our shared responsibility to this land where we live, learn, and work. Thank you. The Misinformation Research Platform is led by Dr. Ataru Chaudhry and is here to speak briefly on this webinar series. Following his remarks, we will dive into our main presentation by speaker, Dr. Uddin. Afterwards, we'll transition into a panel discussion where we'll have opportunities for the audience to engage. So please stay tuned. It's going to be an engaging session. At this point, I would like to invite Dr. Chaudhry.
Thanks, Doug. Can you hear my slide? Can you see my slide?
Yes, we can.
Yes.
Very good. Thanks. So, thank you all for joining us. As Udak mentioned that we have established a platform a few years back. We are calling it as a platform because this is a platform where young researcher and anyone interested in digital development, as well as what we call misinformation or information disorder, we work together, to provide some public good. So we call this webinar series Digital Development, Information Integrity, and Inclusive Innovation. So as you know, like with digitalization, there is so much information. We now live also in the information anxiety age, where it is important to understand how digital development actually contribute to the right development. So when I say right development is like it provides it facilitates development as a responsible way, so that people of all sorts of kind or groups are actually get the benefit out of this development. So this we actually organized a couple of other series for different topic, but this webinar is part of this project. What the title is Enabling Responsible AI-Driven Agri-Food Innovation in Ontario, Challenges and Opportunities. So we started this webinar in May 2004. It's still ongoing. It is part of Ontario Agri-Food Innovation Alliance supported, and we closely collaborate with Livestock Research Innovation Corporation and other producer organizations. So the main background of this project is that, as you know, probably there is a lot of inspiration about digital development in Ontario, with especially Grow Ontario strategy. And there is a particular focus in increasing agri-food technology and adoption. And there is quite of investment that's being done with different kind of producer and community groups. But the adoption of especially robotics and AI technology, robotics is one part of the AI, the bigger artificial intelligence technology. There are, of course, some adoption, but you can see that there are a number of issues related to node adoption too. So for this project, actually, we will look at a couple of issues related to reviewing different AI technologies, especially in livestock and also horticulture sector globally, and also in Ontario-based technologies. And we, from that review, try to identify some emerging AI technology in the Ontario horticulture and livestock sector. And then our three objective is more empirical based. We'll try to assess adoption of those technologies with specific cases and provide some recommendation. And then finally, we will try to develop also recommendation for especially high capacity needs, the people who actually work in AI agriculture sector. So we started with a review and stakeholder engagement. We're a little bit behind, but I think we can catch up. Based on this review, we will actually move to more survey and AHP analysis in the second year. And then we will do a review of capacity needs. And based on that, we will also do a little bit survey and interview, especially focusing on capacity needs for digital technology adoption. Well, I mean, those who join here, definitely when it needs, we will reach out to with some collaboration on that, especially with data collection. This is just a little bit of introduction of the project that we are doing and about the webinar series. But I think I'm sure we all are excited to hear from Mahatab Uddin about a very kind of I would say a little bit new topic in that domain we are working. Thank you very much for that.
Thank you very much, Dr. Chaudhry. We'll now move over to Dr. Uddin for his presentation. Dr. Mahatab Uddin is an adjunct professor and postdoctoral researcher at the School of Environmental Design and Rural Development at the University of Guelph, Canada. He's an expert in climate change and intellectual property law, technology transfer, and sustainable development. Dr. Uddin has extensive experience in digital policy and in building legal frameworks for AI-driven climate-smart agricultural practices. Welcome, Dr. Uddin. You may go ahead with your presentation. Thank you.
Thank you, Duak, and good morning, everybody. My today's presentation is titled as Legal and Ethical Aspects of Deploying Artificial Intelligence in Climate-Smart Agriculture. Basically, on this same title, I have published an article back in 2022, and it has been published by AI and Society of Springer. So today I will try to demonstrate in brief what we have found so far through my research. I can see do you see my slides? Like PPT?
No, we're seeing your email.
Yeah. Dr. Athar, I think Professor Atharul is showing slide from his end.
Okay.
Yeah. So basically, before going into detailed presentation, I would say, what is climate-smart agriculture? Climate-smart agriculture is a way of agricultural process where agricultural activity reduces greenhouse gas emission in atmosphere, which enhances more production and also which helps farmers to adapt to it changing climate or changing environment. So when we think about application of AI in climate-smart agriculture, there are a couple of sectors where AI can be deployed. Professor Athar, I think audience is not watching the slide.
Can you see the slide or not?
Yeah,
No.
now it's possible to see. So you can see there are several sectors like in crop management, soil management, water management, forest management, and also in some other sectors where we can apply machine learning or deep learning based AI technologies. However, today's topic is more about legal and ethical aspects and how is these technologies, these legal aspects especially, can be dealt with. So there are, on the following slide, we can see there are some challenges of deploying AI in climate-smart agriculture. For instance, first I will say some ethical concerns. You can see data inaccuracy and wrong recommendation related ethical concern, data ownership related issues. There are some digital division issues because all farmers don't have equal access to AI technologies, and also privacy and security issues. This is especially for when farmers provide their agriculture related information to the technology provider or to a specific technology, then they are actually scared of or they have some concern about privacy and security issues of their data. And before that, data ownership is the big issue. And when farmers provide their data to any technology provider or to any specific technology, they think like this data are actually commercially usable. So there is a concern of ownership. Who owns this data? Basically, another issue is data inaccuracy and wrong recommendation, because sometimes algorithm based on which AI work don't function as it is expected, and sometimes based on wrong data, it can give us wrong information or wrong suggestion. I think slide is not visible again. So apart from these ethical concerns, or to deal with these ethical concerns, actually, there are some legal issues, especially for data inaccuracy and wrong recommendation related issues. There are some legal issues which I will especially focus on. That is, that you saw like criminal law, tort law, intellectual property law, and data ownership law. So I will today especially focus on criminal law and tort law and how these can be dealt. This can be applied, especially when any wrong recommendation are provided. The challenges of deploying AI in climate-smart agriculture is actually based on or also concerns difficulty in data interpretation due to local differences, technical limitation of using AI in the agriculture sector, detrimental outcomes based on incorrect data or inaccurate data, as I mentioned just, and inaccurate data could lead to biased decisions and errors in climate-smart robot recommendation. So on the fourth point, I will see how law works or how law can deal this fourth point. On the following slide, we can see, for instance, there is a question, what happens if a robot makes a mistake? For example, if it causes injury to a farm laborer or trespasses onto a neighboring farm, what happens? On the following slide, we can see like there are two ways to deal with this issue. First one is criminal law and second one is tort law. As you all know, criminal law is a cases where damages are derived from any ubiquitous wrongdoing against society. So for criminal law, if someone is accused for any criminal offense, he can be punished through either jail or mostly through sending jail or also giving some monetary fine or monetary penalty. But in case of tort law, this happens in cases where damages are derived from any negligence. It can also happen from any product liability issues. But in tort law, it is mainly for getting compensation and damages for the victim. On the following slide, we can see, Professor Atta, on the following slide, can we see? Yeah, for applying criminal law, we need two special things to happen. For instance, Number one is actus reus, which means voluntary criminal act or omission from the act. It means to accuse someone for criminal offense, the person or the entity needs to do something criminal act knowingly or voluntarily. And the second one is mens rea, and whoever accomplished the criminal act, he must need some guilty mind or intention to commit a crime. So in case of robot-run agricultural technologies or any robot, so if we want to put this element to a robot, in that case, we have to make sure that sufficient awareness like human is like present within robots. And if AI-based robots or other technologies have their own mind and free will as humans have, the current legal system will require actually huge amendments also. So it is still under debate whether it is possible to give a legal personality or any human-like personality to a robot. So until then, on the following slide, Professor Athar. So until then, we can apply some existing principles which are applied for criminal law or for bringing someone into criminal punishment system. First one is we call perpetrator via another. It means if any offense or any wrongful act is committed by any entity that lacks mental capacity or the ability for mens rea, for instance, a child or mentally deficient person, in that case, this perpetrator via another principle is applied. For instance, if one person is not sound or he is child or minor or mentally unsound, in that case, the person who is sound and who has enough mental capacity to give direction or to give suggestion to do this work, this man actually will be responsible for any wrong thing done by those minor or those unsound person. In this case, if we consider the robot doesn't have any sound mind, or robot is not capable of taking his decision on his own, so the person who direct the farmers or any other person who actually suggests or who operates the robot can be liable for any criminal activity done by any robot, especially in climate-smart agricultural robot. Number two principle is actually natural probable consequence. For instance, in any case, if there is no conspiracy, we don't know that conspiracy is there, but still an accomplice can be held liable, legally liable, if that person can think that or it is apparent that doing this work will naturally or consequently be result into harm to another person or to result in any criminal act. If it happens, this natural probable consequence can also be applied in case of climate-smart agricultural robot technologies. For instance, if a farmer orders his climate-smart robot for doing something in his field, and he knows that he didn't limit the robot's area of work, and it may result in doing some harm to neighbor's farm. In that case, the farmer who guides or operates this robot can become responsible for criminal act under this natural probable consequence principle. And actually, indeed, number three element or principle of being or doing criminal punishment or bringing criminal law here is actually direct liability. If we apply this direct liability principle, in that case, actually, both actus reus and mens rea are attributed to an AI or to a robot. It means in this case, we think that AI has a human-like sense and capacity to take decision. Robot has human-like capacity to take decision on his own. and he has both actus reus and mens reus, in that case, this robot will be responsible on his own to do any criminal act. However, in that case, actually, the robot can also use some defense. I mean, they have some defense under current criminal law. For instance, if he claims that he was unsound or he has insanity, which is applicable for normal human actually in real life, he can say that he was infected by any virus or malfunctioning AI system. In that case, that can work as a defense of insanity or unsoundness. So it means applying criminal law in climate smart AI technology or robot technologies in cases of any harm it happens to any third party. It is not easy to establish the criminal punishment system or criminal charges. Especially, it is not easy for direct liability system or direct liability principles. It is applicable for, or it is understandable that the first two principles, natural probable consequence or the other principle, that is possible. This is because someone human who guides or directs the robot. So the human can be responsible here, but not the robot. So while criminal law becomes a little bit tricky or a little bit difficult to prove that who is responsible for any criminal act, in that case, we can think about tort law. Tort law is it's a civil wrong. It's a way of punishing civil wrong or wrongful act. That is not actually punishment. That is mainly about making sure compensation or damages. So a civil wrong or wrongful act, whether intentional or accidental, from which any injury occurs to another, can be brought under tort law. So it provides relief to injured parties for harms caused by others, imposing liability on parties responsible for the harm, and deterring others from committing harmful acts. And it covers wrongful acts and injury caused by other AI-based technologies into the climate-smart agriculture, or technology used for climate-smart agriculture. Following slide, Professor Athar. If we go to the following slide, we can see for applying tort law, we need to prove two things. Or actually, there are two elements here. One is actually negligence element, and another is product liability element. For negligence element or for negligence doctrine, it holds people liable for acting unreasonably under the circumstances. And to provide a negligence claim, the plaintiffs or claimant need to prove that, actually need to prove four things. First, the defendant or the wrongdoer had a duty to care of the plaintiff or the claimant, and that the defendant or the accused has breached his duty to the plaintiff. And number three is there must be a causal link, or there must be a relation between the defendant's breach of duty and the plaintiff's claimed harm, or the claimant's harm, what he suffered or she suffered for. And number four is the plaintiff had suffered damages as a result of defendant's claimed breach of duty. So number four is he must prove that the harm he faced or he suffered is actually a result of the wrongdoing. This negligence doctrine can be applicable actually in climate smart agricultural AI and robot if it can be proved that the guide or the director or the farmers or the operators had actually had some negligence element or had these four elements when someone caused harm, suffered harm. The following slide, and apart from negligence doctrine, another doctrine is actually product liability doctrine. It means like if someone suffers from any harm, he needs to prove that, or there must be a faulty AI or robot there who actually who committed something which resulted in actually harm of the victim. So types of defects can be in a product, can be design defects, can be manufacturing defects, can be failure to warn the users that the manufacturer should have done before that the operators should be warned that this AI or this robot can result in sometimes these kind of flaws or this kind of problematic issues. However, in many jurisdictions, manufacturers or sellers can be held strictly liable for harm caused by defective products, meaning the injured party does not need to prove any negligence things, only that the product was defective and caused harm. If it can be proved, then it is enough to say that this product manufacturer or someone related with manufacturing will be responsible for the losses. It can be happen in a car's brake system in an automated car. To prove a negligence claim, the plaintiffs need to prove that the defendant had a duty to clear the plaintiff. Well, it has been told before on the following slide. Yeah. So if an accident happens, two elements become relevant. So negligence and productivity. And under the product liability doctrine, we can see that there must be risk utility test. It means the person who claims any harm, and who claims that the harm has been resulted as a faulty product, as the use of faulty product, he needs to prove that the product, whether a manufacturer is liable for injury to a consumer because the risk of danger created by the product's design outweighs the benefits of the design. He needs to prove that this product faultiness or this fault of the product is actually more than, or even proportionately more than, the benefits he gets from using that faulty product or from using that product. Proving this element, like product liability doctrine, through risk utility test is not so easy. So this is because sometimes it needs, or in most cases, it needs some expertise opinion, some opinion from the expert, and it needs some complex test and process. However, in strict liability concept, if it is clear that the product has some manufacturing default and it is visible and apparent from a normal eye, from a sane person's view or eye, then it is not essential, or it may not need to go with this complex process of risk utility test. On the following slide, we can see actually then who can be punished or who can be brought under this system of punishment or fine or any penalty with this faulty product doctrine. It can be a program designer, it can be a product expert, it can be superior agents, who guided the manufacturers, or who suggest, or even sometimes it can be who guided the operations or operators or farmers. It can be agribusiness manager, technology developer, manufacturer, operator of the AI technology, distributors, suppliers, retailers, technology provider, or any other entity who makes the product available into public. And finally, if you have any question, thank you so much. I thank you so much for listening this presentation. And before that, and going into any question session, I would like to conclude in two ways. Like under current system, it is tort law still, which is more preferable than criminal law to get any punishment or to get any compensation or damages for harm caused by AI-run climate smart technologies. And obtaining compensation of damages caused by errors made by AI-based climate smart technologies may be easier than bringing the concerned technology or technology provider under criminal punishment system. This is because bringing criminal punishment system needs to make sure who will go to jail, and it is actually really hard to determine currently under current legal system who will go to jail. jail. This is because AI do not have legal personality, and robots cannot go to jail currently under current system. So it may be the directors or the who designs or who suggests or who operates the AI system, but still it is under development to decide who will be punished under criminal system. So till now, it is tort system which we can think of as a like a way of getting reward or getting damages or any compensation. Thank you so much for listening, and now I will wait for any question if you have.
Thank you. Thank you very much, Dr. Uddin, for such an interesting presentation. Definitely a dimension that we need to consider, especially as AI becomes more and more integrated into our daily lives. So at this point, I would like to invite you to a panel discussion where we'll have some questions. And I would like to encourage the audience to engage. Please feel free to indicate, come on camera and ask questions, or drop your questions in the chat box. So, Dr. Uddin, while we wait for people to, come up with their questions, I have one question for you.
Yeah.
Dr. Uddin?
Yeah, sure, please.
Yes. So how can liability be assigned if an AI robot causes significant environmental damage? We're talking about water pollution, due to probably over application of fertilizer or pesticides.
Thank you, Doc, for a nice question. Basically, under current system, as you heard from the presentation, we can currently divide or think about some liability division. For instance, for any this kind of malfunctioning AI or any harm caused by AI, especially for environmental reason, we can first think about manufacturer liability. We can think who has designed it, who designed the AI and robot, and what kind of responsibilities we can confer on them. If we consider about manufacturer liability, it can be product defects issues. It can be lack of warning issue. For instance, first we will find if the problem was happened just because product was faulty and manufacturer was not careful about to resolve this faulty product. Now, second, we have to think if manufacturer has warned the users before or the technology buyer before about this fault. If he has warned before, then this will not go to, or if it was not that kind of faulty product, then it will not go to the manufacturer. The liability then can come to the operator who has operated this AI or this robot. For instance, if it is farmers or if any other agent who was not conscious enough to at the time of applying this AI. If we think about operators' liability, then we have to think whether he was negligent enough, whether he was not conscious enough, or whether he was not adequately supervised or not. For instance, if these two elements are not fulfilled with these users, we can also think about some others to share this liability to other people, like programmer. Who has programmed this AI? Who has designed this AI? Was there like any faulty algorithms? Was there any bias or error in training data? These kind of things we should take care about. And finally, we can if we're not sure whom to confer this liability, it can be also shared liability. Sometimes all these three actors can also be responsible for these issues. And one more thing, like there are some jurisdictions where it can be also like strict liability. It means it's no matter, especially if it happens in environmental cases, no matter actually who has designed it, or no matter who has made the algorithm, maybe the person who has used it, who was the final user, can be liable for all harms caused by AI. This is because there are some strict liability, and there is no option of thinking second options in these cases. So in this manner, we can divide the liability of these kind of harms.
Okay. All right, Dr. Uddin, we have several questions here. So
Sure.
we have a first question here, which says, is anyone in the AI or automation space gathering precedents from other robotic deployments, that is in automotive? And a question which says, yeah, Chuck, do you want to go ahead with the question?
I just wanted to, the reason why I'm saying that is that, you know, automation in agriculture and this kind of stuff it's new to ag, but robots have been working in factories for 30 years. And you could also argue that that an autonomous system operating in a machining plant, they've been around for 30 or 40 years. So how did those precedents transfer over? Like this isn't exactly a new space. Maybe the AI piece is new, but automation is not new. And I'm just wondering if is anyone in the space kind of getting ready to say, hey, what laws and rules already apply? You know, for example, electrical safety, you know, remote disengage switches, monitoring, you know, human detection, that kind of stuff.
Thank you so much for this nice question. Basically, it can be relatable with, there is a real life case about Uber's self-driving car accident. It took place in 2018, and a self-driving car vehicle actually killed a pedestrian in Arizona. And actually, in that case, we found that the Uber avoided the criminal charges, but the safety operator was charged with negligent homicide. So it means under current automation technology system, the person who is the final user or the final guide of the automation system is currently becomes responsible for negligence actually. This is because it is considered that he was not conscious enough, or he has duty to make sure that this automation system doesn't create any harm to other people. This is the one example actually, which is more interesting. There was another example of like, there was a autonomous drone attack. It happened, a UN report actually, in UN report says that it happened in Libyan civil war. There was a drone who has automatically attacked some humans without getting any prior direction from anybody. So this has become a serious issue of discussion, especially in case of using drone or autonomous system in war or warfare. So, but the system is still developing, and international law is trying to make some legal framework on that application. These two examples currently comes in my mind.
Chuck, do you want to go ahead with your second question?
Yeah, and I think the other question, you've touched on it a little bit, but you know, farmers are asking about using drones, for example, to spray pesticides. And one of the concerns that we have is off-target application. So this is where the pesticide does not actually get applied to the target crop that it was supposed to get applied to. You know, so the simplest example would be, I'm going to use this drone to spray glyphosate. And that glyphosate, the wind picks it up and blows it off of that field, and it lands on the neighbor's crop and kills the neighbor's crop. So that's one example. Or the other example is that the drone doesn't stay within its boundary and just, you know what I mean, just kind of goes outside the boundary. And you know, there's lots of levels of liability there. So obviously you have the drone manufacturer. So, you know, did the drone manufacturer goof up? You have the manufacturer of the nozzle that's actually applying the chemical. You know, was that nozzle incorrect? You have the operator of the drone. You know, was the operator, did they not follow the instructions? You have the farmer who ordered the pesticide. You know, they're the ones who actually asked for the job to be done. Are they liable? And so there's a lot of gray area in this, and the issue that we're up against is that in a traditional environment, if I am driving the sprayer myself, like if I'm driving a machine, you know, then I'm the one doing it. The issue with a drone is how does one prove that the drone made a mistake? Like, how do you actually prove that there was a software programming issue that caused that, you know, how, like, and who is liable to make that proof? You know, the operator might say, hey, I read the manual, I did exactly what the manual said. You know, the farmer who ordered it says, I wasn't even there, right? The chemical company says, I just sold the product. So now we're right back to the drone manufacturer. So how do you know, what standing, like, how do you actually prove that the drone had some kind of software error? Like, how does that actually even happen?
Thank you so much. I think it is very much procedural question, and actually the criminal justice ensurement system has like country to country it varies, but basically the common way of thinking or resolving this issue is actually sharing liability among all possible perpetrators and going into deep investigation.
I was actually afraid you were going to say that.
And actually, but to be like from victim's point of view, the best way to get compensation is if there is an strict liability. In that case, the final user who should have been careful about using this, maybe he can claim this responsibility, this compensation from them. But basically, the solution would be, the best solution would be in future maybe having diverse way of getting insured the products, and like application of insurance companies will be like much more in visibility in future, I think, because
wow. What the insurance companies have done now in agriculture is they're just refusing to insure the application at all. They just will not provide insurance. That's what they've done. They just said, we're just not doing it. That's what I'm afraid of too.
That's very unfortunate, and perhaps a legal framework will also cover this issue in future, and it's essential. I think they should like have some directions on which product insurers companies should not avoid getting insurance or giving insurance. But it's very interesting and very thought-provoking question actually, how to or who will insure this in future in our research team also. I think it's an important question to go further.
Thank you. Thank you very much for that wonderful question. And Dr. Uddin, thank you for your response. We have another question, and it says, is purposely not validating an AI system under a known risky situation considered a criminal act or just negligence? Would you like me to take the question again? So yeah. David would like to know if the owner of a robot or an AI system purposely does not validate the AI system, will that person, or can that situation be considered a criminal act or just negligence? Oh, David is here. Perhaps he could take the question.
Thank you. David, can you like specify or rephrase that question in like in a sentence like whom you want to bring under criminal system or tort system?
Well, my question is, at what point does it become criminal? Because the people who build and validate the equipment are responsible for how it gets used. And if they know that there's a likelihood that something might happen, then they should validate that the system can autonomously prevent that from happening, because that's the purpose of autonomous, right? So just like Chuck was saying, it should not go out of the boundaries of the field. So to validate that, you have to put the drone into situations where it then course corrects so that you actually have validated that it can prevent things from happening or course correct when they do happen. And therefore, then you can claim that this is a system in control and therefore safe. If you purposely don't do that because it's hard to do and you may have difficulty doing it 100% of the time, you're like, well, if we do that, then we're actually showing our system doesn't work. So let's just not test that.
Thank you,
You
David.
know, the
Yeah,
same thing happens with autonomous cars. They can only test so many situations, and they know some situations are very hard to manage autonomously and others aren't. And so they purposely don't put them into those situations. Like all regulations, you want the lowest hurdle test to get your regulations approved as a producer.
Well,
Thank
and
you.
I think to add on to that, David, is it's also you know, is putting a warning label on there. This might be the follow-up to this. You know, can the manufacturer get off scot-free saying, hey, I put a disclaimer when you turn this on, the user acknowledged that we know this doesn't work or might not work, right? That'd be like step 2 of this question. You know,
Yeah,
is that
exactly.
is that sufficient?
Thank you, David and Chuck, both. Like, I think this is a very good question. And in case of like, if the manufacturer has this kind of warning, and actually it is clear that the manufacturers don't have any intention of doing something which may result in harm to any third party. Actually, he cannot be, on principle, in our current system, he cannot be liable as for criminal offense. This is because he doesn't have both of the elements in hand. Like he doesn't have mens rea, which means he don't have intention to do the harm, and also he doesn't have actus rea. He didn't do it voluntarily on himself or herself. So it's only can be tort law or any civil remedy may take place in this place, as I heard from the scenario. Under current system, actually, so far we can predict this kind of thing, but it's always depends on the like case to case. Court can determine any different scenario and can find out some different facts and principles if needed. But
So
we can
yeah. So you're saying that if the manufacturer didn't have the intention, or didn't have the knowledge that this could happen, then they're
Exactly.
somewhat protected a little bit.
In that case, he can be brought under tort law for giving any fine, maybe, for giving any penalty, but it's not. It cannot be criminal offense on principle. This is because he didn't have any intention to harm anybody through this product.
Mm-hmm. Well, this is the gray area, because your intention not to test and validate is a form of, I think, is potentially a form of criminal omission, because you are the person who understands best the capability and harm that could be caused, and you're purposely not demonstrating its ability to prevent that, because it may be too difficult to do. In other words, the systems are inherently unstable, and therefore you just put a warning label on it because you want to sell the product, even though you know it's going to occasionally go out of bounds, if that's the example.
Yeah.
And so because it's be very difficult for anybody to guarantee that an autonomous system is safe under all circumstances, no matter what. So I feel like there will be some cases where people are criminally negligent because they should have known better, and they purposely undertested. I mean, the automotive industry had this problem with crash test cars and things, the same situation where they did not want to do certain tests because they knew it identified certain flaws. So they tried to manipulate the regulators to saying, these are the only tests that we need to do, and then we get our seal of approval that this is safe and you can't sue us now in a collision. Same principle applies to drones.
Yeah.
David, thank you so much for your valuable proposition. I think it is very similar to the case we had seen in self-driving car or vehicle killed a pedestrian in Arizona that I mentioned. and the court found actually negligent homicide, which means it has been considered as a homicide, as a negligent, but not, we don't find he or the manufacturer had any mens rea or intention to commit that homicide.
Okay.
It's still gray area, and in all over the world, it's we are trying to, I mean, everybody is trying to, in the legal field, is trying to find some principle and legal frameworks to how to deal with all these issues. The only problem is actually technology grows and goes very faster than the law, and the building legal frameworks take years, where taking technology in the field or being technical in the field doesn't take that years, or maybe comes within month these days. But there should be some basic principle of these particular issues on which actually all over the world work is going on. In our paper, we suggested to make an international standard or framework or principles which should be adopted by all countries all over the world. This is because, like, if one standard principle is set, then it will be easier also for the technology developers to think about what kind of technology they can develop and what risk they should avoid on any particular technology.
Dr. Chaudhary, you have a question.
Yeah, and just a comment. I was just listening to this interesting discussion. I think Mahatab, you already mentioned about. I was just thinking, talking to one person in a meeting about. I think she works in Canadian Standard Authority. So I think the reason we are interested in this topic, because I think it will be a future discussion. We can already see there are multiple cases coming. And this kind of research actually can also inform developing a standard. Although I'm not always, fan of standard, especially when it is about agriculture and food, because it's very context specific. But I think maybe the kind of maybe we will not say it as a standard, but it could be a framework, some kind of flexible and inclusive that can help us to, respond to this emerging field of, action and practice.
Thank you, Dr. Chaudhary. Chuck, you can go ahead with your question.
So one of the lead-ins to this is, like, some of this technology is extraordinarily complicated, right? And so, and we have a legal framework that says, a court case needs to happen within a certain time frame, and you've got a piece of AI code that could have taken somebody 3 years to develop. And so having somebody look for a flaw in that code, let's say there's a bias, let's say that the calculations are wrong or whatever. One of the questions that I have is a recommendation being that some of this coding is going to have to be open to the public so that it can be reviewed ahead of time, for some mission critical stuff. Otherwise, the person is going to be inherently liable to prove that it was unsafe. And David talked about this. Like, how do you prove that software is safe in every circumstance? Will the companies, is there any precedence to having a company saying, they have to provide evidence of this ahead of time in some way, shape, or form? That's what I'm getting at. Like, provide the software ahead of time to the insurance company or to the regulator to have them look at it.
Thank you so much, Chuck, for your interesting idea or insight on this topic. I think this is something which I will also add in my future or current research to think further, actually, how to make sure these procedures are in place. Because if it is not, then it is not easy for the technology developers actually to guess earlier what would be the consequence of their developed technology and what kind of force and safety measure they should take up. Thank you so much, Chuck. I will think about this topic also in my research.
My final point would be is that we're kind of in the wild west of this technology. You know, if you think back to when cars first came out in the 1900s, you know what I mean? Like there was no rules of any kind, right? And we're in that space now. And one of the challenges with standards and laws and legalities is that it's so easy to not follow them. Like it's incredibly easy. Like right now, it's illegal to spray with drones in Canada, and there's thousands and thousands of acres being sprayed illegally right now. And so then my question, the lead into this is how do we deal with this in such a wild environment that we're in? Like a self-driving car, like I could build a self-driving car today and put it on the road, and no one could stop me if I wanted to.
Thank you, Chuck. Another interesting question, which I should answer like this one I said before, is also about criminal justice system implementation procedure things and police and law and order situation. Controlling authorities should think about some, or maybe they can use some other technologies and better AI technologies to figure out actually who are inventing and applying technologies without permission. Also, some maybe technology can help also in this regard again. So it's a cycle of technology or AI which we are living currently. But this is another good question to think about, how to stop or how to monitor this unauthorized use of robot or drones or AI technologies all over the country and world.
Thank you, Doctor. Thank you very much. Does anyone have any other final thoughts or questions just before we wrap up? No, not at all. Okay, on behalf of everyone here, I would like to thank you, Dr. Mahatab Uddin, for guiding us on such an engaging and thought-provoking session. Definitely, it's provided deeper understanding on the current legal challenges and a call to action on robust global and national legal frameworks. Dr. Chaudhry, you have something?
Thank you everyone for joining, and we found like this is an interesting topic and that's not really well discussed. Dr. Uddin and I also talked about some other dimension of this topic, and we'll bring more discussion in the new year, and stay tuned for other webinars. Thanks.
Thank you, Duat. Thank you,
Thank you.
David,
Thank
and
you, everyone.
for participating in.
Thank you.
Thank you.
Bye-bye.